Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we're going to talk about two unit holders who each of them own an equal stake in the units issued in respect of a unit trust, and we're going to discuss a piece of litigation that they both got involved in. So let's flash back in time to see how the unit trust venture was set up. We've got a bunch of parties we're going to call the plaintiffs, and the plaintiffs are going to be loosely interchangeable with the plaintiff, but we're sort of going to treat them as one for our discussion. And we've got the defendant or the defendants, and we're sort of going to treat them as one today as well. So forgive me if I'm saying plaintiffs when I mean plaintiff, or defendants when I mean defendant. But what we've got is we've got our plaintiffs and our defendants, and who they are bankers, and they meet each other, they are not especially poor, and they discuss with each other investment opportunities for themselves, and they form a view together that what they'd like to do is sort of diversify their portfolio to include some pretty substantial farm assets, some pretty substantial farmland. And there are emails exchanged, there are messages exchanged, and these sorts of things. And eventually, what they resolve to do is they resolve to purchase a certain piece of land that, as I say, is a very valuable piece of farmland, a substantial piece of farmland. So on making that resolution, what they do is they then think about the structure. How are we going to structure this? And it's your classic business question, right? Is it a partnership? Is it a trust? Is it a company? How are we going to set this thing up? They seek some advice, and what they resolve to do is to set the thing up on the basis that it's going to be a unit trust. And so the plaintiffs kick some money off to the unit trustee, the defendants kick some money off to the unit trustee purchases the land, and things start ticking along. Okay, the farm is being managed by farm management service providers, and over the life of the trust there are discussions between the plaintiffs and defendants about a number of things. One of the things they discuss is farm management services provider A better than farm management services provider B? Who's right to provide services? And they change providers from time to time. They speak about other things as well. They speak about the drought that sort of looms and really comes to affect the position in relation to the value of the land, and it comes to affect things like the relevant cash flow. Are we going to borrow money in order to feed our livestock, or are we going to sell our livestock? How are we going to manage it? They discuss other things as well, such as the potential acquisition of additional properties to make the unit trust have a larger corpus that might include more and more of these substantial rural properties. And so things progress over time, and things run in a way we might think of as reasonably smooth. There are bumps along the way, there are hiccups. At one stage, the plaintiffs themselves decide to purchase a property, and what that purchase does, firstly, is cost a lot of money, and so secondly means that that money is not going to be available for the plaintiffs to loan into the unit trust to sort of contribute to what we might loosely refer to as the joint venture. And so there's a bit of disappointment that the plaintiffs have sacrificed their access to cash that might assist the unit trust in order to pursue their own sort of venture, their own sole venture, if we put it that way, of becoming owner of this specific piece of property. There are frustrations as well that some opportunities to purchase farms are not directed directly to the relevant unit trust, are instead directed elsewhere. These are some of the concerns that bubble along over time. Now what happens is these concerns kind of come to a head over time, and there are frustrations with different managers coming in and having frustrating reports on what should we be doing with the farm. Have we made a mistake in relation to stock? Have we got our proportions correct? Are we doing the right things in relation to management? Did you do the right thing? Did I do the right thing in relation to management? These sorts of things start to bubble along, and a dispute arises. The relationship breaks down between the plaintiffs and the defendants. Now what happens is, after the sort of breakdown of the relationship, there's a position where the plaintiffs cause a number of offers to be made to the defendants, and the defendants reject those offers. And through this time there's been a little bit of talk between the two of, shall we wind this thing up, shall we, and I use the term wind this thing up loosely, and we'll come to the looseness with which I use it. And essentially there's no agreement to wind up the venture, there's no agreement to cause the trustee to sell the assets and these sorts of things. But we come to this position where the plaintiffs are making offers. The plaintiffs want out, the plaintiffs want the property sold, and what the defendants say is, not sure we feel the same way about that. And so we get to the position where the plaintiffs issue what they describe as and what they label as a wind-up notice. Now, as you and I know, you can't really wind up a trust, but that's just a technical point we'll come to a bit later. But the intended effect of that notice is to try to determine the trust, try to bring it to an end and say, hey, let's get this thing to sell all the relevant assets and let's get out of here. And what the plaintiffs say is that's the effect of this notice. Now, the plaintiffs then come to court, and the thing has not yet been wound up, using that term loosely. The trust remains on foot. It continues to own the assets and it continues to bubble along on that basis. So, what the plaintiffs do is they come along and say, look, there are 4 things we want, or 4 arguments we're going to raise in relation to bringing this trust arrangement to an end. The first thing they say is there was an agreement or an estoppel that allows, or that a representation that stops the parties from departing from the position that it was always intended that unilaterally one unit holder could cause the whole thing to come to an end. If that makes sense. The plaintiffs say, look, there's an agreement, or in the alternative, there was a representation made that we relied upon and to our detriment, etc., estoppel stuff, that means that one party could elect to determine the trust relationship for the assets to be sold and for the distributions then to be made to the unit holders in their proportion. And so the court is left to consider this position, and upon considering whether the court accepts that there was an agreement entered into to that effect, or whether there was a representation made that was subsequently relied upon to the detriment of the defendants, the court finds, well, in effect, and indeed, there's not enough evidence before the court to lead the court to a finding that there was indeed such an agreement or there was indeed such a representation. And so the plaintiffs on that agreement/estoppel point fall. The next point the plaintiffs raise is they say, well, the trust should be wound up because of the operation of Clause 2 of the relevant trust deed. And Clause 2 of the relevant trust deed says essentially that the unit holders are presently entitled to the capital of the trust. Presently entitled being a specific phrase used with a specific taxation effect. Now, it's accepted between the parties that the reason the trust deed includes this is to deal with land tax issues that we won't get into here because I won't communicate them clearly enough to you. But in essence, the trust has this clause that says the unit holders are presently entitled to the capital of the trust, and the plaintiffs say, aha, that means that we are entitled to that capital. That means we should wind up this arrangement, distribute out the assets of the trust and get out. Well, the court, for a number of reasons, one of them being that unit holders, the unit holders plural being presently entitled in accordance with Clause 2 of the deed, is not the same, the court says, as each separate unit holder being presently entitled to 1/2 of the assets of the trust, such that they would be able to bring the arrangement to an end. Thank you so much. And so what the court says is, in relation to point 2, which is Clause 2 of the relevant trust deed, cheers, that the plaintiffs are unsuccessful on that point, and so the plaintiffs fail to move the court to make the orders winding up, I use the term loosely as I say, the trust in relation to Clause 2 of the trust deed. And so the plaintiffs then move on to their third argument, and what they say is, well, the conduct of the trustee company has been oppressive within the meaning of Section 232 and 233 of the Corporations Act, and so we should get orders determining this thing. Initially, the court takes a look at the relevant law and says, well, a member or a shareholder for our purposes of a trustee company can argue that a trustee company's conduct has been unfairly prejudicial, and they can do so on the basis that their kind of family beneficiary interest that their role as member of the trustee company is designed to protect has been affected. But what the court does is work through the relevant bases asserted by the plaintiff that the conduct of the trustee company has been unfairly prejudicial, and say in short, no, it hasn't. Now, the reason the court comes to a no, it hasn't position in relation to the conduct being unfairly prejudicial includes because there's a commercial arrangement entered into, and chief of the complaints the plaintiffs have in relation to the would-be oppressive conduct that is found not to be oppressive is disagreements about the management of the company. Remember how it's like, are we going to do stock feed, or who's going to manage the farm, or different opportunities to buy land and these sorts of things? And secondly, the absence of an exit strategy. What I ought to have told you before at that phase, way back when we were talking about the structuring of the arrangement, was that the unit holders did not enter into a unit holders agreement, which unit holders would sometimes do, and that would deal with a how do we exit this arrangement sort of position. They didn't enter into an agreement like that, and so the argument was really about management stuff and the failure of an exit strategy, and that in and of itself does not constitute unfair prejudice to the plaintiffs, and so they failed to move the court to make orders pursuant to Section 233 of the Corporations Act in relation to corporate oppression. And so we move to point 4 that the plaintiffs raised. Point 4 was the plaintiffs applying to have a receiver appointed to the assets of the trust, which is, with great respect, the quote-quote correct thing to do. If you're looking to quote-quote wind up a trust, you want to appoint a receiver to a trust's assets. That's technically what you want to do. In any case, the basis they said for doing that, whether pursuant to Section 67 of the Supreme Court Act or whether pursuant to the inherent jurisdiction of the court, was essentially setting out all the facts they'd complained about before. What the court said was, doesn't look like the trust assets are at risk, doesn't look like the trustee is performing unsatisfactorily, and so it doesn't look like we'll make this order. The plaintiffs raised sort of arguments by analogy to the just and equitable winding up of partnerships and to the just and equitable winding up of companies pursuant to Section 461 sub 1K of the Corporations Act, and the court is also unmoved by those arguments, and so the plaintiff fails on the 4th limit of their application. So what happens is the plaintiff has gone down on agreement / estoppel, has gone down on clause 2 of the trust deed, has gone down on corporate oppression, and has gone down on the appointment of the receiver. And having gone down on all those things, the plaintiff goes down in their application and fails to get the orders thereafter. I hope that discussion assisted you, and I look forward to joining you again soon over another coffee and in respect of another case note. Cheers.